You may proceed when ready.
Thank you. If it would please the court, my name is Jeff Appel. I represent Virginia Young. She's an educator in Polk County, Florida. Sometimes around my office we talk about this as the brownie case, but I think that's sort of giving it a little...
Should be the tree nut case.
The tree nut case. Now I almost brought a box to show you, but I think that might take away from it, the seriousness of it, because a person's ability to maintain their profession was at stake in the matter below. This is a case that I was skeptical to take at first. I was. I just couldn't figure out, after I dug into it though, how the ultimate factual finding that led to the penalty was deduced by the trier of fact and then
You weren't involved
adopted.
below, correct?
No, I was not.
Okay, all right.
I
Because it
wasn't-
appears that there were some inconsistent positions taken below because the proposed recommended order and findings of fact and conclusions of law basically boiled down to she made a mistake, she knew the child had allergies, and really the blame for the incident was on the school's failure to implement guidelines to alert teachers about student allergies. And there was absolutely no challenge as to the failure of proof below. And the only exception that was filed was as to the penalty.
You're right, and that gave me pause when
I
the
bet
case
it did.
came in. It did. And when I studied it and when I looked down into it and when I debated it with those in my office, I came to the conclusion that my best argument for this woman is fundamental error. And that's where I went, as you can see with the briefs. And I'll reserve 5 minutes. I forgot to mention that. Hopefully I won't need it. I'll keep us all on we're doing pretty good this morning. And I believe that the reason the case is one which fundamental error should apply is because even though it's the brownie case, it is serious where the person's rights and ability to proceed with her profession, should she so choose, because the record does show she did retire 2 years ago, but keeping your certificate is important to somebody. We all never know what's going to happen in life. The nature of the charge is penal, so it's a substantial penalty, somewhere between a civil judgment and a criminal conviction, but it is nevertheless penal. Case law follows that. But the nature of the charge turned on 3 relevant facts: that there was a child in her class, he had a nut allergen, she gave the student a wrapped brownie, said don't eat it. If this was me in first grade, that thing would have been eaten immediately. So, but said wait, go check with your mother first. And somehow on the way, in the hallway, as he was being escorted, the student wasn't left alone with the wrapped brownie. The child managed to get down a good portion of it, which I probably would have done too. But at the same, I don't think that's necessarily here nor there, but it is a fact that I have to deal with. The fact the child ate some of the brownie, apparently, from the record. Also, but what the ruling came down to, and the fundamental error is not what she did as far as here's a brownie, check with your mom before you eat it. The ruling came down to not whether that was something that put the student in danger, but the fact that it says she gave the child, an allergic child, a brownie that contained nuts. That's the problem. That's the fundamental error in the case, because there was no proof below at all that there was nuts. And at best, the allergen ingredients said may contain nuts, so you're left with maybe it did and maybe it didn't.
This isn't. Tell me how this isn't a conflict in the facts in the testimony that had to be reconciled by the ALJ as opposed to an issue of law.
Right, and we debated that too. Is this a question of fact, a question of law, or a mixed question of fact and law? And what I've come down to, I think, ultimately in my brief I said it's a question of law because that's my best argument. But it's probably a mixed question of fact and law because you have to have a certain, we have a burden of proof for these cases, and how we apply the facts within the burden of proof is where we get that lovely thing that we shake together and result in ultimate conclusions of law, which are mixed questions of fact and law, but every mixed question of fact and law involves a question of law. So we come down to the burden of proof in the case, and how did the trier of fact, hearing officer going up to then being certified by the ALJ after hearing it, arrive at that conclusion that there was a nut, there was some nut, and that the defendant, my client, gave that to an allergic child, and then that caused harm.
Do you concede that your client knew the child had an allergy?
I do.
Okay.
I do.
Do you concede that your client read the label?
I do.
Okay.
Well, at some point, I don't know if she, I believe the record will show that she read it before, and then
Well, she testified she
I
read
think
the
she
label.
felt it was safe.
Yeah, she testified she read the label, and then she even added that she had some certain degree in nutrition and knew about it, and then she even added in an editorial fashion that, oh, I already know that if it had any nuts, very little or something like that. So, but what is not challenged by her attorney below was the fact that the mom was asked, what symptoms does your child have when he does consume something with tree nuts? And she specified each one. And then afterwards, hold on a second, afterwards when she figured that the child did eat this brownie, she testified that the child had many of the same symptoms that she testified that he had had on previous occasions. That was never rebutted below, so there's no expert testimony here.
You're right.
So what you're saying is you had to prove that there were nuts in there. Well, why doesn't that prove there were nuts in there? Because he had the same exact symptoms that he'd had before when he consumed something.
There's also proof in the record that he went to the doctor later and was diagnosed with a viral
But
condition.
you say that, but I cannot find that in the record. I did a word search. Viral infection does not exist unless my computer
Some
doesn't
kind of
work.
illness, right.
I'm not great with computers, everybody will admit that, but I did a word search and I looked and I could not find any record whatsoever that said the child had a viral infection.
I could be misremembering that, and I'll look for that to
Okay.
address on rebuttal, but I certainly would like to address that. But my argument isn't really to all of the conglomeration of facts. It goes to the fact that the ALJ below came up with a specific ultimate finding that she gave a child nuts that was allergic. And
But
this,
so what?
yes,
I mean, the problem that I keep having with this is who cares if it actually contained nuts or not? The violation is that she failed to make a reasonable effort to protect the student from conditions harmful to learning and or to the student's mental and or physical health and or safety. So how does it matter if it actually contained nuts or not? What if the package had said, may contain poison?
right.
I mean,
And
does it really matter at the end of the day if it contained poison or
Well,
not? Isn't the whole issue the fact that she knowingly gave a child allergic to tree nuts something that may contain tree nuts?
Something
Isn't
that
that really
may
what it-
contain tree nuts with the
Isn't that
instruction.
really what it boils down
Go
to?
ahead. With the instructions to check with his mother and not eat it.
Here, kid, this
However-
may contain poison. Check with your mom before
And
eating
my
it.
analogy was, and thinking this through my mental process was, what if she gave the child a box that said, may contain a gun? You know, I anticipated you would say that. But where I keep coming back to is the burden of proof in this case because it's penal in nature.
But where,
And maybe, just like in your last case, maybe there was knowledge that that water bottle was close, or that there was drugs near the water bottle. But there requires clear and convincing proof in a
But-
penal nature.
clear and convincing proof of what? How is it, and to continue the penal analogy, where is it an element of the offense that the product actually has to contain nuts?
The element of the offense is that well, I don't know, well, I do know that it's an element of defense that the element of the proof of the offense, is what I'm saying, is that the teacher had to do something that was endangering to a child, right? And if you give a child something unknown, something possibly dangerous, you could have violated that statute.
A reasonable effort to protect the student.
Right.
Is it a reasonable effort to protect the student by giving them something that may contain something that will hurt them?
But what we don't know is whether the trier of fact would have reached that conclusion, because the order is hinged. The linchpin of that order is that it says the teacher gave the student nuts.
Isn't that just a superfluous finding?
Well, it's the only finding that supports the conviction, or I'm saying conviction, but the penalty imposed based on that count 3 that was the only one upheld. So the answer to your question is we don't know what the analysis would have been under the totality of the evidence. We don't know, because below the order was written such that it was pinned on the fact that there seemed to be conviction in the mind of the trier of fact that there were nuts given. Not that there was a maybe. A maybe would be a 50-50, and if you're going to penalize somebody, then under a clear and convincing standard, I would argue that a flip of a coin is not necessarily equivalent.
Yeah, but the child got sick. Child got sick. It's undisputed. I mean, clear and convincing is not beyond a reasonable doubt. It's just simply whether the testimony, whether the witness testified with a distinct memory, whether it's precise, whether it lacked confusion. So here, I mean, your client denied it. Your client denied ever being told that this child had an allergy, when documentary evidence, extrinsic evidence, clearly impeached her.
Yeah,
I'm sure she's a sweet lady. Appreciate her service. But you can tell that she was impeached.
Absolutely.
So this ALJ had to reconcile this testimony
Right.
with the unrefuted testimony that the child immediately got sick. Seems to me it's clear and convincing that it had something in there the kid was allergic to, and the only thing is tree nuts, and it was expressly written on that label.
That it may contain the tree nuts.
Well,
In addition to
that would behoove her not to even give it to the child at all.
Well, she, in fact, did give the child the brownie wrapped with instructions, and I can't dispute those facts. I can't. I didn't try the case. I'm trying to make the best argument I can under fundamental error, because I'm saying that the allergy is proven. The fact of the nuts is questionable. It only says may. It's 50-50. Whether it caused harm was only lay testimony, not medical testimony. And all of that leads me to believe that there was a tipping of the scales, a preponderance of the evidence. I suppose we could disagree on what meets clear and convincing evidence, but in a penal nature, there had to be some, I'm arguing, some stronger evidence of the fact that this case turned on, that the teacher did give nuts. You may say that finding is harmless error. That would be in the prerogative of the court. However, she's been penalized on this. I would suggest that there is no evidence of the nuts, and in my most aggressive stance, I would say that the case should be reversed, because there was no evidence of the nuts. There was no evidence, except for lay testimony, that the child became sick afterwards. Therefore, there's not enough to impose the penal nature. However, more realistically, I believe the case, and I'm arguing that the case would be appropriate for remand for an analysis under the proper burden of proof, under clear and convincing evidence, and so that we can parse out whether that fact, whether the trier of fact did make the determination that there was nuts, and what the basis was, and that she did put the child in harm's way based on all of the circumstances, or was it just because the trier of fact assumed that there was nuts? Because the ingredients label read may, and when you read the order, it's very clear in the order that there was a finding that there was nuts, and there wasn't. Thank you. I'll reserve the rest.
May it please the court, my name is Ron Weaver. My response will be very brief. The ALJ in this case was well aware of the correct standard to apply. That is clear from paragraphs 25 and 26 of the recommended order, where the ALJ defines what clear and convincing evidence is. The ALJ also stated 2 times in 2 separate paragraphs, paragraphs 23 and 31, that the petitioner proved by clear and convincing evidence that respondent provided a food product that contained tree nuts to a student known to have a tree nut allergy. Now the appellant now wants this court to find that the ALJ did not apply the clear and convincing standard, but a lesser standard in making that finding. What I'll do now is just briefly state what the standard of review is in this case, and cite the cases that I think are applicable in your determination of how this case should be resolved. There are 3 cases that I think that are on point, that have the specific language that I think this court should apply in this case. 3 of those cases we've cited in our brief: Dyer versus Department of Insurance, McKesson Drug Company versus Williams, and the Tedder case. And also another case which I think is applicable is the Contractors versus Gibson at 63 Southern 3rd, 802. And real briefly, the appellate court's duty is to review the record in the light most favorable to the prevailing party and to sustain that party's theory of the case if supported by competent and substantial evidence. And now this court, as you well know, the law is not to substitute its judgment for the administrative law judge, nor is it this court's function to determine whether evidence as a whole satisfies the clear and convincing standard of proof. These functions lie solely with the trier of the fact, and the scope of review is limited to whether the record contains some competent and substantial evidence, which it does. And I think you're exactly right. It doesn't matter whether the product in fact contained tree nuts. The label said it contained tree nuts. The child got sick. The mother went through a lot of efforts to inform the administration, Ms. Young, my child's allergic to nuts. Don't have my child around nuts. And in fact, as you can see from the record, on one occasion, Ms. Young says, well, what if I have a game that I want to play with walnuts? The mother says, let me know, and I'll make sure my child does not come to class that day. So she made every effort to make sure that this child was not exposed to any kind of nuts. Ms. Young knew about the allergy. She knew that the label on the product said may contain tree nuts. Yet she failed to make that reasonable effort that was required in order not to violate the rule. And that reasonable effort would have been to make sure that she didn't provide that student with any product that may contain tree nuts. I think when you look at those cases that I just cited, you'll see that the courts give great deference to the findings of fact of the administrative law judge. The administrative law judge is allowed to draw reasonable inferences based on the evidence. The administrative law judge is allowed to reconcile any conflicts in the evidence, and that is what the administrative law judge did in this case. And based on those cases and the facts of this case, I think the only alternative is to affirm the finding of the administrative law judge and the final order of the Education Practices Commission.
Thank you, sir. Thank you. Rebuttal?
Thank you. Again, I would simply point to the order and saying that there was a specific finding that the product did contain nuts, and that there was not clear and convincing evidence of that specific finding. Whether or not the conglomeration of the evidence would have justified the same result is not known. Therefore, we would request at the minimum a remand. And I thank you for your time.
Thank you, sir.
Thank you, sir.